Hey, Brian Parker here, Attorney Brian Parker. I'm coming with another fantastic video. This one is July 4th week. So it's kind of relaxed. I got a little window in my very busy day. So I'm going to do, I felt like giving you something free this week. So I'm going to give you, it's titled Free Cheat Sheet for Figuring Out Bill of Sales and Assignments. So I've given you a free video and cheat sheet on creating a counter affidavit. There it is. Slowly, slowly, swish. And I've given you a free PDF, how to create an answer using your rules and laws of your state. And there's the icon, and that's creating a free debt collection answer. And those are two cheat sheets. So I'm creating another one, or I have created one, a free cheat sheet for figuring out the bill of sales and assignments. So just like when we're doing a deposition, I want you to be like an attorney deposing someone. And my staple in telling you how to do a deposition is to remember who, what, why, how, where, and when. Who, what, why, how, where, and when. Let me just put that on there, Shazamski. And what I want you to do is, I always use this word, I love this word. I want you to look through a prism of how, what, why, how, where, and when. And so what we're doing is we're looking at a document, and in this case we're looking at bill of sales and assignments. A lot of times debt collectors, to really gin up and add credibility to their bill of sales, they say bill of sale and assignment, and neither one is true, as we're going to show you. So I want you to look through the prism. Every time you look at a bill of sale and assignment, I want you to take my free cheat sheet, and I put a little box there so that you check off, check off, check off, check off. So at the end of that check off, you'll have an accumulation of why their stuff is so bad. And let's do this so we can kind of get you through this. A free video for a free cheat sheet. So the first question we ask is who? We ask, the company selling, is the company selling or assigning? You know, we talked about how sometimes I'll go bill of sale and assignment. I had one transfer of sale and assignments. They throw in as many words as they can, figure people don't have time to read. And that's what you're going to do with the who, what, why, how, where, and when. You're going to go who, which company is selling? Why is that important? Well, let me put up an oldie but goodie, a typical velocity bill of sale. Shazam. It's typical. I'm going to read this so I get this right. You can see in the second line, Upstart Funding Grantor Trust 2021-3. And then they talk about how they're initial seller, but really all nonsense, flowery words, doesn't mean a thing, and it actually screws them up. But the first question is who? Who is selling? Well, Upstart Funding Grantor Trust 2021. Okay. And what gives them the authority to sell anything? So the sentence before that is, for value received pursuant to the terms and conditions of the purchase and sale agreement. You've heard me talk in terms of forward flow agreement. Every debt by a sale or assignment is premised on a forward flow agreement. And that's a deal between the original creditor and whoever they're selling debts to. They'll say, hey, we're going to sell you millions of debts down the road. Let's have an agreement. And every once in a while they amend it. Debt collectors, debt buyers, debt law firms do not want you getting a hold of that. So what's the first thing I always go for? There you go. So if you get in the weeds, go for the forward flow agreement. I've never seen one attached to a bill of sale, even though it says pursuant to. So if the company pushing this thing to the plaintiff, in this case, it's Upstart Funding Grantor Trust. Cindy, make sure it's still up there. They must have the right to sell or assign the thing. And that's a common thing with velocity bill of sales. They'll attach a bill of sale and they'll say, hey, we own it and we got it from this guy. Well, who gave it to Upstart Funding Trust? So who is selling and who was the assignee or assignor to whoever's selling to the plaintiff in this case? This is a good example of a broken chain of title. The first bill of sale, they have Upstart Funding Grantor Trust, and it's always Cross River Bank or Blue Ridge Bank is the original creditor, but you never see them giving anything to Upstart Funding. So look for that. Who is giving, who is taking. Then the next box is what. What is being assigned or sold, or how? Accounts, receivables, those certain receivables, and to what extent. That isn't tongue-in-cheek. They literally will say, to the extent that we own it, we're passing it on. Present it to the court and say, look, there's a bill of sale from A to B. You have to read what they actually say. So look for the what. What is being assigned? Is it a debt? You'll rarely see the word debt. You'll see accounts. You'll see receivables. You'll see actually something that says those certain receivables, as I said. It's all nonsense. If I give you my car, I don't tell you it's sort of a 2020, 2016 Chevy, Oldsmobile, Volvo, to the extent that I own it. No, I go, here's the car, there's the VIN, here's my signature, that's how much you paid. That's it. Don't make it harder. Why do they make it harder? Because they don't own anything. So ask your what. The debt, always, where is the debt? Maybe I jump to where, but the what, you're assigning something. The debt that you're being sued upon must be inside that assignment. Just like if I sold you my car, I'd sign my name as the original owner, and on the back of the title, it would say Brian Parker to Jenny Jones. She signs how much and the VIN number. Very easy. And then you can go to you can register the car and go sell it to somebody else. Why isn't that the case with these debts? Because they're hiding something, the fact that they don't own it. So look inside. What is being sold? That's a critical question. If you have what's called an excerpt, a lot of times you'll have an excerpt attached to a bill of sale or an assignment, and the plaintiff will go, look, judge, yeah, it isn't, Parker's right, but right next to it, we've got, and they call it, and in the business it's called Exhibit A or an excerpt. And they'll go, here's all these that are all blocked out, all the debts inside this bill of sale, and they'll leave open just you or your client's name and address and some other nonsense. But there's nothing certified, and indeed there's nothing saying that that excerpt is attached to that bill of sale other than the attorney says it so. But that's not reliable. That's total hearsay. There must be a signature, and we'll get to the signatures on bill of sale, attached to the excerpt, the separate piece. Again, if you took your car in and you tried to register your car, you wouldn't have an extra piece of paper attached to the title. They'll look at you and go, what are you, crazy? It's either on the title or it isn't. So that's the case here. So why? Why is the debt or account being effectuated by this signer or company? In other words, a good example is, I love this. Let's put up a Lynn Fisher bill of sale. Shazam. So that's, so the bill of sale, this is a resurgent acquisition. So whenever you see resurgent, that means there's an LVNV funding at the end of this. And they're saying these companies, Synchrony Bank, formerly known as GE Capital, you can read it, RFS Holding, Synchrony Card Funding, Retail Finance Credit Services. These companies are supposedly selling to resurgent acquisitions. And on the screen you can see a Lynn Fisher has signed, by the way, she signed way after they say the accounts were sold. She signs in 7/5/2023, and she somehow wears the hats of Synchrony Bank as a SVP recovery operator, a duly authorized signatory for RFS Holdings. You can read Synchrony Card, and then she's a vice president of retail finance. So that's all well and good, but you have to have an authorization of her to sign on the line that is dotted. And there's no authorization here. And by the way, where are the assignments between all these companies? You don't get to just say, well, look, there's this and this, we own it. You have to have an assignment of your specific debt, not accounts, not receivables. It has to say, in this case, Synchrony Bank sold it to RFS Holding. There's the assignment. RFS Holding sold it to Synchrony Card Funding. There's the assignment and credit card now. So that you get the point. This is worthless. But you've got to come at it with this cheat sheet. So how? Every bill of sale goes through what's called a forward flow agreement pursuant to its terms and conditions. In one form or another, it says that. It'll say master purchase and sale agreement. And other times it'll say master purchase and forward flow agreement. So it won't always say forward flow agreement, but look for the terms pursuant to these terms and conditions. If you want to win your case every time, everybody wants that, right? I want a pill that does it all. Ask for the forward flow agreement. Now, you will get harassed by the other side going, they don't need that, it's trade secrets, blah, blah, blah. Then why does it say it in the bill of sale pursuant to that? So if something is pursuant, for example, if I sued you breach of contract, I'd have to have the contract. Pursuant to the terms and conditions of the contract, you didn't pay, and Section 5 says you're in default. Just the same way, this is a contractual relationship. If they're claiming they own a debt, in other words, they're claiming they own a contract, they have to show what gives them the right to do that, to buy it or get it or be assigned by the original creditor. And if they're mentioning it in the bill of sale, see every single bill of sale, you're entitled to it. You'll settle the case. Where is the document being sued and by whom? What authority does the signer have? The signer. Am I serious? Signer have. Spelling error. So look at, as we said, the authority, the authorization. For example, with Lynn Fisher, she had no business signing for anybody. I did some research, obviously you do too. She worked for Synchrony Bank, Recovery. I don't know if one of those is even mentioned on there. Somehow she has this authority. It's not improper of you to go, can I see the authority for her to sign off on these, and where's the assignments? So what authority does the person signing have? And are they, an employee of these companies that she claims she has the right to sign for? And when I say where, by the way, like I just did a case where it was a Citibank in South Dakota, the one person signing's from New Jersey, and the debt is located in Virginia. All in the same, I'm like, are you kidding me? Can't you at least make it a little more difficult for me? So when I say where are these being signed? Like I just did a motion response 10 minutes ago where this person on June 24th signed for Citibank to, I think it was LV&V Funding or Resurgent on June 24th. And then on June 24th in South Carolina, she's in Ohio, and June 24th in South Carolina, somebody from Resurgent signed saying, yep, we got it. We gave it to LV&V Funding. On the same day, hello, I mean, they had to drive pretty fast, or maybe there's a special Amazon or FedEx drone. But that's my point is, those dates are important. Check your dates. Where was it signed? When? Again, check those dates. If the agreement is supposedly executed on June 17th, but Ms. Fisher signs on July 5th, that deal did not go down till July 5th. You have to sign everything for it to be executed. But then you'll see right inside the bill of sale, we gave everything to LV Funding on June 17th. Well, nobody gives their car everything, anything, until the deal is done. So that shady language is something you should key on. So look at the bills and sales of assignments and use my cheat sheet to then obviously create and dump that into, using their own documents against them, into your counter affidavit, which goes into your answer and affirmative defenses, which can go into your counterclaim and protect you along the way. Here's some other considerations. Let me put them up. Shazam. Look for proof that the signer or notary who they say they are. That's fun. You see a note, somebody was notary in Virginia, and you go look, they're not. I actually start shaking because I'm like, there's no way. way. Once in a while you get that, it's mwah. Again, I've told this story before. I would be in college. I got paid for college by being a store detective. So I had to look through these heating vents to watch people when they stole stuff. And I never believed my eyes, but my heart would go a million miles an hour. That's the same feeling I get when I find someone's lot misrepresented and isn't a notary or assigned, in Ohio one day and South Carolina the next day. And it's impossible because there's their Facebook picture saying, hey, I'm in Aruba. So I love that stuff. Another one, ask for the forward flow agreement. Always, debt buyers, creditors, law firms don't want you to have this and will fight you. All the secrets that show the debt is really as is and probably isn't inside that bill of sale. Know the assignment law in your state. Some states say the debtor has no right to complain about the assignment. It is not a party to it. And that's a common real estate thing. So, and it was I did a lot of foreclosure defense, trying to keep people in their houses. And I see how phony these chain of titles were. Bob for Chase Bank, giving it to this company. I go, that's not right. So I go check the signatures, and I got really good at this. And they were all robo-signed. They're all fake. So I go, Judge, we win. He go, the rule in this case, Michigan, is if you're not a party to the assignment, you can't complain about it, which is really rude. However, that is the general rule. The exception is if you can show fraud or that it's void, now you have a right to complain because it affects you. It affects you either way, whether you can't show that. But that was real estate law back then. Also, what do the pleadings allege about the bill of sale assignment? I catch debt collectors, they pump this crap out. And I've given you tons of videos on this. They'll say, yeah, it was assigned on March 8th, 2023. And you look at the assignment, it's April 15th, 2024. But so you can go, here's their own pleadings, contradicting their own documents. It's a mess, but they haven't met the burden of proof. So those pleadings, those documents are incorporated in my number one rule, 1A. What is it? Hello? What do we use? What documents? That's right again. We use their documents and their pleadings against them. So let's take a quick look at a couple of bill of sales. We just looked at two. Here's some oldies and some favorites of mine. We're going to put up an upgrade one dated September 25th, 2019. Shazam. So it says, and here's cool. Now, reading is fundamental. Speaking is too. It's fun. So look, upgrade a Delaware corporation and UHG, whatever DELLC is, buyer, executed a purchase agreement forward flow dated, and there's that word, forward flow, August 16, 2019. That's not selling your debt. It's just telling you the weather in Delaware is cloudy going into the 60s. This is just saying there's an agreement between these two entities. So maybe later on, for value received and in further consideration of the mutual covenants and conditions set forth in the agreement, the investors reference, investors, I thought this was between Upgrade and UHG. So this is not what it purports to be. But the attorney comes in and goes, we got a bill of sale from him to him. And if you don't read it, you're going to miss that it's really talking about investors. What investors? That's right, the thing was securitized. You've got the word investors. So there's a whole bunch of assignments and sales that occurred before this went down. So let's read more. So the investors referenced in Exhibit 1, hereby transfer, sell, convey, grant, deliver to buyer. So the buyer is to UHG. It successes and assigns the account set forth, yada, 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 delivered by seller to buyer on the closing date. Makes no sense because there's no sale between Upgrade and UHG yet. So let's read on. On September 25th, each investor reference will sell or cause to be sold a pool of accounts. I mean, that thing's so securitized right now. And it's each investor's yada, yada. So I'm going to show you what this really is. It's called a bill of sale. You're about to learn what this is. Upgrade Inc. represents and warrants that each of the undersigned investors is executed a limited power of attorney. That's all this is. It's Upgrade's power of attorney to act for the investors. So I'll tell you what they're really doing. They are shoring up all the ownership of this debt that just got broken up in pieces when it was securitized. Now they have to sell it, this debt, or a ton of debt, to UHG that's paying them a ton of money pursuant to the forward flow agreement. But there's all these owners of the debt. So, you know, instead of going, hey, could you give me the sale? Could you give me the sale? Could you give me? They just go, Upgrades has a power of attorney for each investor. So my discovery was, please name each investor and what part and what role they played in the sale. Case settled. So this is nothing more than what's called a power of attorney. My mom is sick and my sister is a drug addict, and the minute my mom loses her brain, sister's going to move in and take her stuff. So I get a power of attorney over my mom, and I'm the only one that can access her bank accounts, work on her car, sell things to keep her going, and it keeps the sister at bay. That's what this is. That's just your basic power of attorney. That's Upgrade's right to sell and buy stuff for each investor. But each investor has to be named, number one. Number two, this is not a bill of sale. That, in the complaint, they said it was. It's kind of cool. UHG, with some attorneys, they're really bad. And so this is BS. It's not even a bill of sale. So look for that stuff. Should I give you one more? Yeah, this is that one I wanted to tell you about. So affidavit of sale of account, Shazam. And this is a Lindy Kane, an employee of Citibank in Sioux Falls. She's authorized, she says, to do all this stuff on or about blah, blah, blah. Citibank sold a pool of charge-off accounts, the accounts by a master purchase and sale agreement. There's your forward flow agreement again. You go for it. As part of the sale, the account, and here's that word again, certain electronic records were transferred on individual accounts to the debt buyer. All right, what was happening and to which individual? See, it just floats off. So that was occurring in Sioux Falls, right? Wrong, because we've got a notary that says we're in Missouri, Jackson County. And the actual affidavit, if you look up top, says state of Missouri, okay, county of Platte. So in the county of Platte, from someone in Sioux Falls, a notary from Jackson County has signed, yep, it's all true what was said up there. So just read, man. What did I just do there? I did the how, what, why, when, where. Just use that sheet to go through these things. There's a little guide. It's a free PDF cheat sheet for you. And it will get you out of a lot of debt. It will win the case. And have that little thing in your pocket, that chip, that, okay, I want to see the forward flow agreement. That case will get settled. Okay? So I hope this helped. Get my free cheat sheet. As always, please like, love, subscribe. We'll keep rocking it out. There's 30 years of nonsense, good nonsense, in about 30 minutes. I hope I didn't take too much of your time. Thank you very much for listening and putting up with this. Bye-bye.